and the Lauterpacht Center for International Law. My name is Mikhail Kalinin. I'm a board member of the Arbitration Society, and I will be moderating this lecture today on its behalf. A few quick housekeeping points first. Please remember to mute your microphones during the lecture, but do send your questions in the chat. And also be welcome to unmute yourself at the end to ask questions or make any comments orally. Please also know that this lecture is being recorded, but everything said by the speakers is subject to the usual caveat that the statements cannot be attributed to their law firms. The topic of today's lecture is investment structuring and restructuring and its impact on investment protection. The lecture will feature two brilliant speakers, Agnieszka Zarówona and Giorgio Risso. Giorgio is an associate in the international dispute resolution team of Cleary Gottlieb. He has experience representing multinational corporations and sovereign states in disputes across a range of industries, including telecommunications, media, financial services, and energy and natural resources. He has represented clients in arbitrations under the ICSID, ICC, and UNCITRAL rules, as well as in court proceedings involving cross-border issues and foreign jurisdictions. Before joining Cleary Gottlieb, Giorgio practiced in the London office of Hogan Lovells and was a research fellow at the University of Genoa and King's College London. Agnieszka is an associate with White & Case's international arbitration group based in London. She focuses on public international law and investment arbitration across a variety of sectors and has also experience under the ICSID, UNCITRAL, and SCC rules. She also has experience serving as a secretary and assistant to arbitral tribunals. Agnieszka is New York qualified and both common and civil law trained, holding Master of Law degrees from Harvard Law School, University de Poitiers, and the University of Warsaw. She also is ranked as a future leader in international arbitration. And finally, and most helpfully to today's lecture, Agnieszka frequently advises on investment structuring and is a co-author of a recent article on the effects of disposal of investments published in the Journal of International Arbitration. The order of the presentations today will follow what can be described as a restructuring timeline. That is because the law and consequences of investment restructuring depends heavily on the moment of that restructuring. And one can see four separate stages. So the first stage includes investment structuring or restructuring before a dispute becomes foreseeable. The second is when restructuring occurs against the background of a future potential foreseeable dispute that has not yet occurred. The third stage includes restructuring that occurs after a certain specific dispute has already arisen. And fourthly and finally, restructuring is also possible when arbitration is already pending. So Giorgio will kick off the lecture and address the first two of these stages, and Agnieszka will follow and speak on restructuring that takes place after a dispute has already arisen. Giorgio, over to you.
Thank you, Mikhail, and good evening, everybody. Let me see if I can share my screen. Okay, here we go. Well, first off, I wish to thank the conference organizers and my fellow speaker, Agnieszka, for this great opportunity. I'm really glad to be back, although virtually, to my old university. Now, let's see what's on the menu for the next 25 minutes or so. My presentation is divided into three parts. In the first part, I'll explain why investors seek or should consider seeking investment restructuring advice when they plan on investing in a foreign country. In the second part, I'll provide an overview on what to consider before structuring an investment. And in the third part, I'll flag a few issues relating to investment restructuring. I'd like to start by saying that investment structuring is a fair share of the work of most arbitration lawyers, and I do consider it to be quite fascinating for two reasons. First, you get to work with clients at a time when they are proactive and optimistic because they are realizing a project, usually a long-term project, rather than litigating because something has gone wrong. Second, you get a chance to work closely with colleagues from other departments in your law firm, from M&A to tax, who will give you their opinion on whether the proposed structuring is doable and how it should be carried out. So, how does investment structuring work in the context of treaty protection? The basic rules of the game are pretty simple, and everything begins with an investment treaty, either a bilateral or a multilateral treaty, whereby each contracting state offers to protect investments made by nationals of the other contracting state according to the terms of the treaty. As you all know, the standards set out in investment treaties are usually broad and provide for a high level of protection. This is especially true of treaties belonging to the so-called old generation. They include, in most cases, protection against unlawful expropriation, the obligation to grant fair and equitable treatment, and full protection and security, and so on. In addition, most investment treaties provide for ISDS clauses. This explains why investors are, or at least should be, interested in investment treaties. In terms of numbers, as of today, there is some 2,298 bilateral investment treaties in force and 324 treaties containing investment protection provisions. It's thus very likely that whatever country an investor may want to invest in, that country will have at least a few investment treaties in place. Now, the position of an investor changes dramatically depending on what's the investor's home state and the state in which the investor intends to invest. I'm going to flag just a few potential scenarios. So, first scenario, our investor is very unlucky because there is no investment treaty between its home state and the host state. Here, investment structuring can definitely help. In particular, it could be sufficient for our investor to structure its investment through a country with which the host state has an investment treaty in place to take advantage of the protections set out in that treaty. On screen, we have the example of a Turkish investor that wants to invest in Peru. There is no investment treaty between Turkey and Peru. However, there is an investment treaty in force between Peru and the Netherlands. By channeling its investment through a Dutch subsidiary, the Turkish investor could avail itself of the protections set forth in the Netherlands-Peru BIT. Second scenario, our investor is not that unlucky because there is an investment treaty between its home state and the host state. However, it may be the case that the investment treaty is not particularly advantageous. For example, the treaty could adopt a narrow definition of protected investor or investment, or it could provide for limited substantive protections, or again, there could be something wrong with the ISDS clause contained in the treaty. I'm thinking of, for example, the BITs concluded by Turkey, which provide for a cooling off period of 12 months. Who wants to wait that long to bring an investment claim? Here too, investment structuring can help. Our investor could structure its investment through a country with which the host state has an investment treaty containing more favorable provisions. Of course, the ideal scenario would be that in which the investor's home state and the host state have an investment treaty in place which provides for a suitable level of protection. A question investors frequently ask is whether investment structuring is lawful. Some authors list investment structuring among the factors that increase investors' opportunities for foreign shopping. And foreign shopping is normally deemed to be something bad that should be avoided or at least limited. In international investment law, it is generally accepted that investors are entitled to structure their investment to maximize treaty protection. Arbitral tribunals accept that investment structuring is lawful and consistent with the purposes of investment treaties. The often quoted Aguadaltunari tribunal said that, and I quote, It is not uncommon in practice and absent a particular limitation, not illegal, to locate one's operations in a jurisdiction perceived to provide a beneficial regulatory and legal environment in terms, for example, of taxation or the substantive law of the jurisdiction, including the availability of a BIT. Investment structuring requires careful planning and tailored legal advice. There are several factors that should be considered to select the most appropriate investment treaty in the context of investment structuring. The first factor to take into account, and quite possibly the most important, is how the chosen investment treaty defines the term investor. This goes to the scope of application, ratione personae, of the treaty. In this presentation, I only focused on the definitions of investor applicable to legal entities. Of course, the definition of investor plays a paramount role in respect of natural persons too, especially when it comes to dual nationals. Now, with regard to companies, most investment treaties contain the so-called pure incorporation test, which provides that a company validly incorporated in its home state is covered by the treaty. This is the definition used, for example, by the Greece-Cuba BIT of 1996. Other investment treaties, such as the Germany-China BIT of 2003 on screen, require that the company have its seat in the home state, alternatively or cumulatively with the incorporation. A few treaties combine the place of incorporation and or the seat with the requirement of the existence of a real business activity in the place of incorporation or seat. This is the approach used, for example, by the Colombia-Switzerland BIT of 2006, which is also on screen. Finally, sometimes the notion of control is used and companies incorporated in third states or in the host state under the control of nationals of one of the contracting parties may qualify as protected investors. So it's quite evident that treaties providing for the pure incorporation test are, in most cases, the best option for investors seeking to structure their investment. These treaties simply require that the investor be incorporated under the law of the home state to attract treaty protection. In Tokyo Stockless versus Ukraine, a Lithuanian incorporated company commenced investment arbitration proceedings under the Ukraine-Lithuania BIT. On screen, you see that Article 1, Paragraph 2, Letter B of the Ukraine-Lithuania BIT defines corporate nationality by incorporation. Ukraine challenged the jurisdiction of the tribunal, including on grounds that claimant was not a genuine Lithuanian entity, given that 99% of Tokyo Stockless and 2/3 of its directors were of Ukrainian origin. The tribunal stated, quote, "Under the terms of the Ukraine-Lithuania BIT, the only relevant consideration is whether the claimant is established under the laws of Lithuania." The same approach was adopted by the tribunal in Yukos versus Russian Federation. Here, claimant was a company incorporated in the Isle of Man that commenced ancestral proceedings under the ECT. Article 1, Paragraph 7 of the ECT defines investor as a company or other organization organized in accordance with the law applicable in the home contracting party. Russia objected to personal jurisdiction on grounds that claimant was a shell company. The tribunal held, and quote, "On its face, the ECT contains no requirement other than that the claimant company be duly organized in accordance with the law applicable in a contracting party." So now, the case law we just went through shows why investment treaties adopting a pure incorporation test are in general the go-to treaties for investment structuring purposes. To the contrary, treaties containing other ratione personae requirements may be more problematic and are usually disregarded in a structuring context. Another factor to consider in structuring an investment is the presence in the chosen treaty of a denial of benefits clause. Denial of benefits clauses can be defined as provisions allowing the host state to deny investment protection to claimant companies if, among other things, they are owned or controlled by non-protected investors and have no substantial business activities in the home state. Denial of benefits clauses raise numerous issues that are intertwined with the wording of the relevant clause. Just to mention a few of these issues, do denial of benefits clauses apply automatically, or does a state have to exercise its denial of benefits rights? If a state has to exercise its denial of benefits right, when will this exercise be considered timely? Are the effects of the exercise of denial of benefits clauses retrospective or prospective? Now, there isn't enough time to dwell on each of these issues, so I will just briefly show how denial of benefits clauses can affect investment protection. So the first case on screen is Guaracaki versus Bolivia. Here, Guaracaki, a company incorporated in the US, commenced ancillary proceedings under the US-Bolivia BIT. Guaracaki was controlled by nationals of a third state and had no substantial business in the US. Bolivia argued that the tribunal lacked jurisdiction over Guaracaki pursuant to the denial of benefits clause contained in Article 12 of the BIT, according to which, and I quote, each party reserves the right to deny to a company of the other party the benefits of this treaty if nationals of a third country own or control the company and the company has no substantial business activities in the territory of the party under whose laws it is constituted or organized. The tribunal made two important points here. First, the tribunal said that denial of benefits clauses are a matter of jurisdiction. These clauses place a limit on the host state's consent to arbitration. Second, the tribunal confirmed that denial of benefits clauses operate retrospectively. And in the words of the tribunal, the very purpose of the denial of benefits is to give the respondent the possibility of withdrawing the benefits granted under the BIT to investors who invoke those benefits. As such, it is proper that the denial is activated when the benefits are being claimed. Other tribunals have reached a different conclusion. So in Plama versus Bulgaria, respondent invoked the denial of benefits clause contained in Article 17, paragraph 1 of the Energy Charter Treaty. The wording of Article 17, paragraph 1 is similar to that of Article 12 of the US-Bolivia BIT we have just seen. Here, after establishing that the denial of benefits right must be actively exercised by the state, the tribunal concluded that denial of benefits clauses operate prospectively and that a state must put the investor on notice. I quote the relevant part of the decision, which is on screen. It is not unreasonable or impractical to interpret Article 17, paragraph 1 as requiring that a contracting state must exercise its right before applying it to an investor and be seen to have done so. Now, the Plama Tribunal adopted a more pro-investor approach, which other tribunals have followed, in particular under the ECT. Yet the presence of a denial of benefits clause in the chosen treaty remain an element that investors structuring their investment should pay close attention to. Ultimately, treaties containing these clauses are usually disregarded for investment structuring purposes, as there is a concrete risk for the investor of being deprived of treaty protection. So, in the remaining time, I'd like to briefly touch upon investment restructuring. Sometimes clients come to us because they want to restructure their investment in the host state. This may happen for a variety of reasons. For example, when an investor did not initially structure its investment with a view of taking advantage of treaty protections. Investment restructuring raises the same issues we have discussed so far about investment structuring, plus a number of additional issues. The issue I'm going to focus on is timing. Depending on when restructuring takes place, respondent states may raise two objections: an objection to jurisdiction, ratione temporis, and an objection for abuse of rights. The difference between these two types of objections was explained by the tribunal in Lau Holdings versus Laos. The relevant passage is on screen. So the time frame corresponding to a finding of abuse of process is not the same as the time frame corresponding to an objection ratione temporis. If a company changes its nationality in order to gain exit jurisdiction at a moment when things have started to deteriorate so that a dispute is highly probable, it can be considered an abuse of process. But for an objection based on ratione temporis to be upheld, the dispute has to have actually arisen before the critical date. Thus, investment restructuring undertaken when a breach of the chosen treaty already occurred won't be affected, usually. This is in line with the principle of non-retroactivity of international treaties. Abuse of process is more tricky. Again, there is no time to go into detail about this topic, so I'll just do a high-level analysis. In a nutshell, to assess whether investment restructuring amounts to an abuse of rights, arbitral tribunals usually consider whether the restructuring was motivated only by the desire to obtain treaty protection or undertaken at a time when a specific dispute was foreseeable, or a combination of the two. In Phoenix Action versus Czech Republic, the tribunal had to decide about the lawfulness of a corporate reorganization undertaken in the following circumstances. In April 2001, the Czech authority launched criminal investigations against Mr. Bejno and seized the assets of the two Czech companies he owned. Mr. Bejno fled to Israel and registered Phoenix Action under Israeli law to acquire the two Czech companies and bring a claim under the Israel-Czech Republic BIT. The tribunal concluded that claimant's corporate restructuring was unlawful because the investment was not made for the purpose of engaging in economic activities, but for the sole purpose of bringing international litigation against Czech Republic. In Philip Morris versus Australia, the tribunal adopted a different approach centered on foreseeability and concluded that there is an abuse of right when an investor has changed its corporate structure to gain the protection of an investment treaty at a point in time when a specific dispute was foreseeable. I quoted from the award. Yet, in that case, the tribunal also considered the purpose of the corporate reorganization in connection with claimant's argument that the reorganization was motivated by tax reasons. The tribunal wasn't persuaded by the evidence offered by claimant and concluded that the main, if not sole, reason for the restructuring was the intention to bring a treaty claim. So, in conclusion, the validity of a restructuring process and the applicability of the principle of abuse of rights largely depend on the facts of the case, which need to be considered carefully when giving investment restructuring advice. So this concludes my presentation. Thank you for your attention.
We have not had any questions thus far, but please do send them and then we can discuss them at the end. Agnieszka, would you like to start? And Giorgio, I think you have to shut down your slides first.
Absolutely, would love to. And thanks so much again to Mikhail and organizers for inviting me. It's really a pleasure to get to Lauterpacht. It's obviously quite the dream for many of us public international lawyers. Needless to say, it would be much nicer if we were able to meet in Cambridge. Alas, here we are in multiple locations, which also has its advantages. All right, so let me just set this. Bear with me while I try to share a screen. Right. All right, I think this should work.
It does.
Perfect. Very well. Thank you for the confirmation. All right. Now that Giorgio has masterfully introduced and led you through the intricacies of structuring and restructuring of investment, I will cover what, at least so far, has been a subset or a more of a niche issue with respect to the topic. Namely, I will speak about the investment structuring that may occur post-treaty breach, and in particular, how that affects or may affect the jurisdictional issues before the tribunal. Or in other words, I will focus on what Giorgio described as when something has gone wrong. So without further ado, sorry, I'm just trying to click my way through, but there you go. Okay. So the scenario before us, I will first provide you with the scenario that we will focus on. Then I will survey the investment treaty cases on point where the tribunals were faced with these issues, and all that to try to answer the big question, whether there is a general rule of continuous ownership and that applies in investor-state disputes or not, or maybe it applies only to certain cases. And I will also say a few words about the impact that issue has or may have on damages. Now, the scenario. Imagine that there is an investor from state X, from state Y, and let's call it Investco, not to be too creative. And Investco invests in state X, and it can be any type of investment. Investco may have acquired a company in state X, which is quite an often the case. It may have real estate properties. It can have a concession, really any type of investment. Let's assume that there is a bilateral investment treaty between state Y, which is the home state for our Investco, and state X, which is the host state for the Investco's investment. As usual, everything goes well until it doesn't, and then the horror. State X breaches the protection obligations under the BIT towards Investco's investments. Now, Investco's investments become either virtually worthless, or Investco no longer wishes to remain in the jurisdiction, given the treatment that its investment has suffered at hands of state X. Investco is considering to bring a investment treaty claim under the BIT and against state X, but at the same time, it's not quite sure whether it wants to stay with its investment in state X. So what can it do? Can it divest? Can it sell its investment if it wants to bring a claim, or does it have to hold on to it just for, say, jurisdictional purposes? And this is the exact question that we want to address. what is the relevant point or points in time at which the investor, Investco, being the prospective claimant, must establish its ownership of an investment for the purposes of its funding. Well, it's tried to say that an investor must have had ownership or control, depending on the treaty language, over the investment at the time of the alleged treaty breach, forming the basis of its claim. However, is there a requirement that the investor retains the ownership until the arbitration proceedings are afoot, or even until the arbitration is completed? And a margin note here, when I refer to rule of continuous ownership, at times it might ring to some of you as the rule of continuous nationality, which is rather a distinct concept because with continuous ownership, we focus on the investment and its ownership structure, whereas with nationality, we focus on the investor and obviously their nationality, because otherwise it would be a misnomer of a rule. The latter, the rule of continuous nationality, is quite an interesting topic, but that would be a separate one from what I will cover today. Coming back to continuous ownership, let's take a look at a timeline, and I must admit that I am trying to chase Giorgio's masterful slides with beautiful maps and flags. So I was trying also to make a bit of an effort and make it more visual. So let's take a look at that timeline. To obtain protection under a treaty, and by extension access to the treaty's dispute resolution mechanism, there must be a qualifying investment. This is because most frequently protection under investment treaties is offered to investments as opposed to investors. So our investor must hold to the investment, as I said, at the time of the treaty breach. There is abundant arbitral practice to that regard, and that's fairly well established. However, if the investor divests before the treaty breach, any state actions pertaining to that investment can no longer form a basis of a now former investor. So if Investco held its investment and it sold it, and only then, after the sale has occurred, the state X takes measures which are in breach of a treaty, Investco would no longer be able to bring any claim with respect to those breaches which post-date the transfer of its investment. But does the investor need to retain the ownership after the treaty breach occurs? Well, unless the investment was directly expropriated, in which case there is nothing to hold on to, is there any other point at which the arbitral tribunal should look at to assess the investor's standing to bring a claim? What about the notification of a dispute to the state if it's so required under the treaty? What with the institution of the proceedings, however defined under the applicable rules? Does the investor need to hold the investment throughout the arbitration up until the award? Those are all very good questions. And as always, when any questions are approached, one needs to first go to the treaty itself. Typically, BITs do not contain provisions stipulating that investments must be held at the time the claim is submitted to arbitration. And that can be seen in the provisions providing for the dispute resolution mechanism. And it's fairly common that that would not be the case. And at least I have not seen a single BIT that would require that, which, however, bearing in mind, as Giorgio said, there is over 2,200 of BITs, and I admit I have not read all of them in preparation for this lecture. So I'm happy to hear otherwise from the audience. Equally.
Sorry to interrupt, just before you move on, I think you haven't changed the slides. So if you're trying to use them.
Oh, really? That's very disappointing. Well, please bear with me because. Thank you for telling me. It's really huge loss for you if you're not seeing my slides that I labored over.
Now see the stages.
Let me try sharing again.
We see the presentation, but I mean, you haven't, now you have changed it. It was stuck.
Oh, wonderful.
Just, yeah.
Okay. Excellent.
Right, now we can see it full screen as well.
Okay. All right. Now it seems to be working. Thank you for shouting out. All right. All right, let me just find my way around now, back to where I was. Sorry, bear with me. Okay, hopefully we are where we should be now. Okay, so going back, treaty provisions. I just said that BITs typically do not have provisions that establish rule of continuous ownership. Now, equally for ICSID cases, Article 25 of the ICSID Convention, forming part of the basis of jurisdiction of ICSID tribunals, does not include any reference to ownership or control of an investment. And that is in contrast to requirements regarding the party's nationality as covered by the definition of a national of another contracting state under Article 25(2) of the ICSID Convention. As you will recall, these require that the nationality be assessed on the date on which the parties consented to submit the dispute to arbitration, and for individuals, but not for juridical persons, also on the date on which the request was registered. Recently, a NAFTA tribunal was faced with a question whether NAFTA requires claimants to retain ownership of their investment for the purposes of certain claims. Under NAFTA, an investor has two options to bring a claim. It can either bring a claim on its own behalf under Article 1116, or it can bring a claim on behalf of its enterprise. And the enterprise under NAFTA is the local company that the investor owns or controls in the host state under Article 1117. In a fairly recent decision, 2019, in BMEX versus Mexico, a multitude of claimants brought claims both on their own behalf and on behalf of local enterprises, so relying both on Article 1116 and 1117. Importantly, there was a number of changes in the ownership of the local enterprises at various points in time. Mexico, having seen that myriad of changes, argued that the claimants must show ownership and control over the enterprises at the time of the submission of the claim, in addition to the time of the treaty breach. The tribunal agreed with Mexico. It relied to that purpose on language of NAFTA Article 1117 and noted that it, and I quote, uses the present tense. An investor may make a claim on behalf of an enterprise of another party that is a juridical person that the investor owns or controls. So this owns and controls was what led the tribunal to understand that this is required at the time of the submission of the claim. The tribunal went on to say that where the investor no longer owns or controls the enterprise at the time of submission of the claim, it can no longer pursue an Article 1117 claim on behalf of the enterprise. The tribunal did not find such language in Article 1116 and noted that a claim on the investor's behalf does not require subsistence of the investment at the time a claim is submitted. While NAFTA, as you may know, is on its way out, being replaced by the USMCA, the United States, Mexico, Canada FTA, similar provisions to Articles 1116 and Article 1117 are present in multiple free trade agreements, for example, the CUArb and a multitude of other FTAs. Now, so this sort of shows an example of a treaty that actually may have provisions which, under at least some interpretations, would establish a rule of continuous ownership to the extent that ownership must continue at least up until the submission of the claim, if not thereafter. Now, let's turn to cases where tribunals were not faced with a NAFTA-specific language or a BIP language, which would prompt them to see a rule of continuous ownership. Let's look at the timeline we discussed before and focus on changes to investment ownership after the arbitration is afoot and up until it completes within the award, when the award is rendered. So between the institution of the proceedings and the award. In cases where claimants disposed of or transferred their investments after having brought their investment claims, respondent states typically objected to the tribunal's jurisdiction based on the claimant's supposed loss of standing. And that loss of standing would allegedly result from their divestment, saying you no longer hold the investment and therefore you cannot bring the claim. Claimants, on the other hand, would typically argue that the tribunal's jurisdiction should be assessed at the time of the institution of the proceedings, because presumably in all those cases, the claimants knew that they met that particular timeline, so they were happy just to concede to that timeline as sort of suiting their case, their factual positions. Let's take a look at a couple of examples. In Encana versus Ecuador, the claimant invested in two wholly owned Ecuadorian subsidiaries. The claimant submitted its notice of arbitration against Ecuador in March 2003, and just 6 months later, once the arbitration was pending, in November 2003, the claimant sold its stake in one of the subsidiaries, and fast forward to 2005, when the arbitration was still ongoing, because as we know, these cases take a while to come to a conclusion. The claimant announced that it planned to dispose of the remainder of its investments in Ecuador. At that point, which is far along in the proceeding, Ecuador objected that by the virtue of those divestments, the claimant lost standing and was no longer an investor, quote unquote, as defined in the treaty. The tribunal considered the treaty language and found that the sale had no effect on its jurisdiction, and the tribunal focused on the fact that the loss or damage, as the language that was present in the treaty, crystallized at the time of the breach. And that was the only point in time relevant for the tribunal's jurisdiction. Another example is National Grid versus Argentina, where the claimant invested in an Argentinian company, which in turn invested in another Argentinian company, which in turn invested in another Argentinian company. So as often the case, we have a chain of ownership spanning through indirect investments. The claimant submitted its notice of arbitration against Argentina in March 2003. A year later, in August 2004, the claimant sold its shares in the local company to a third party. And at the time, and similarly to what Ecuador did in Canada that we just discussed, Argentina objected that the claimant was no longer an investor. And that's a novel argument at that time, moment in time. If anyone, Argentina said that if anyone can bring an investment claim or pursue that investment claim against Argentina, it would no longer be National Grid, the claimant that sold its investment, but it would be the buyer company that purchased the investment sold by National Grid. Obviously, claimant disagreed. The tribunal dismissed Argentina's objection and found that the critical date to meet the jurisdictional requirement is the date when the proceedings are instituted. It also found that under the terms of the share purchase agreement between National Grid, the claimant, and the buyer of its Argentinian investment, the claimant retained the right to pursue its investment claim, as such right had not been transferred to the buyer. As such, the tribunal noted that the terms of the divestment instrument, be it an SPA or any other mode of transferring investment, may be relevant for the tribunal's jurisdiction. And we will see this pattern in a couple of more cases that were decided by tribunals, where the divestment happened after the proceedings were commenced, and that's El Paso versus Argentina, Lauterpacht versus Thailand, for example. Now, let us look at, and I will speed up because I see that time is precious. Let us look at cases where divestment occurred before arbitration was launched. That is, after the treaty breach occurred, but prior to the institution of the proceedings. In Gemplus versus Mexico, there were three claimants, Gemplus, Industrial, and SLP. And they invested in a Mexican entity that held a concession in Mexico. The concession was revoked in 2002, and that was the payment. Fast forward 2 years, in early 2004, that is after the treaty breach, Gemplus sold the shares in Gemplus Industrial to yet another company in the group. And Mexico objected, noting that that sale meant that Gemplus lost standing, which it held through Gemplus Industrial. The tribunal rejected Mexico's objection, and in doing so, it relied on a memorandum of understanding that was entered between the three claimants, between Gemplus Industrial, and SLP. And that's a throwback clearly to what we discussed about National Grid, where the instrument of the sale becomes important. So the tribunal looked at the memorandum of understanding, which stipulated that to the full extent permitted by law, Gemplus and Gemplus Industrial retain all rights they currently have in relation to the claims as defined to be claims against Mexico, and there shall be no effect on such rights by virtue of the transfer of the shares to SLP. And then the memorandum went on to say that SLP would, as the buyer, would participate as needed in the proceedings against Mexico. The tribunal decided that the legal effect of the memorandum of understanding entered into by the claimants was such that, and I quote, GEMPLAS retained all rights to maintain its existing claims as advanced in these proceedings against Mexico under the BIT. By doing so, the tribunal confirmed that it is possible to separate the right to bring a claim under an investment treaty from the bundle of rights pertaining to investment itself. Similar findings allowing claims where restructuring occurred prior to commencing arbitration were made by the tribunal in another case against Argentina, that is Daimler. And now we come to a case where the tribunal looked both at the effect of the disposal of investment prior to bringing of a claim and after. So there were a couple of changes in the ownership, and that's Aven versus Costa Rica. In Aven, the tribunal, the claimants made investments in Costa Rica, and there were quite a few of them, through locally incorporated commercial entities, which in turn owned parcels of land, which claimants wanted to use to develop a resort, basically. The claimant submitted a notice of intent in 2013, a notice of arbitration in 2014, and then Costa Rica challenged jurisdiction of the tribunal, which happened fairly late in the proceedings, but looking at the case, one can see that there was a lot that was happening and that there was a lot that claimant was not very forthcoming with, providing information about the structure of the investment at various points in time. And Costa Rica claimed that prior to and during the course of arbitration, the claimant sold parts of their properties to third parties and failed to disclose these sales to the tribunal and the other side. The tribunal assumed that the relevant date for assessing its jurisdiction is the institution of the proceedings. And then it held that, and I quote, the relevant case law instructs that in general terms, an investment sold after the date of notice of arbitration meets the criteria for investment in terms of the CUArb, the underlying treaty. On the other hand, an investor who disposes of ownership of an investment in question before arbitral proceedings should not be eligible to seek the treaty's protection unless special circumstances are present. Such circumstances include, inter alia, the loss of the investment by the actions of the third party or the retroactive application of a treaty. So we see that the tribunal seemed to reject the rule of continuous ownership of investment, but still it adopted the position that the relevant date for assessing the ownership lies at the date of initiation of arbitration, and the subsequent divestment, while it would not in principle, does not affect jurisdiction, but the prior one will be protected only in special circumstances. So this is a more nuanced approach, diversifying between various moments in time that the investment can be transferred. And I see that I am running out of time, so I will just briefly say that what we discussed were pertain to sort of a gateway for arbitration as to whether you have, an investor has to keep the investment to get through the door for the tribunal to have jurisdiction. However, the issue can also have some effect on the damages, because that's the other side. And as we well know, while the claimants are happy to go through the jurisdictional stages, what they truly care about is really damages that will be awarded by the tribunal. And in those terms, a couple of tribunals have held that if the investment was sold after the treaty breach, then the sale price should be deducted from damages that they award. But in a couple of other cases, it doesn't seem that the tribunals actually went through the exercise of subtracting the price from the damages that they awarded. So in conclusion, just to run through it, there is no clear line of cases, but a number of decisions rejected a rule of continuous ownership unless present in the treaty. The divestment after the proceedings are instituted may be a safer option if it, between the two. The terms of the sale agreement and the applicable domestic law may be relevant. And lastly, there may be an impact on damages. And that's it from me.
Wonderful, thank you so much. We do have a few questions. I think we can take the first one for now. I'll just read it out loud so that everyone can hear it, even if you don't see the question itself. So the question is, what is considered by restructuring? Incorporation is in a given jurisdiction for the purposes of nationality seems to be the usual situation, but would it also cover any other types of corporate arrangements, like buying a majority to ensure control of the local enterprise? And are there any cases on such arrangements? So I think Agnieszka mentioned a few of those cases, but I'm also wondering if perhaps Giorgio has a comment on, because it touches on control. Nationality.
Yeah. So it's quite difficult to say what's corporate restructuring and to provide an all-encompassing definition. Let's say that I would say that corporate restructuring is basically any operation which has the purpose and the effect of putting a bilateral investment treaty or multilateral investment treaty where there wasn't any before. And this can be done in a variety of ways. I mean, there is no limit to the creativity of corporate lawyers. Of course, it can be done by transferring shares. I think that this is what was done in Philip Morris versus Australia. The shareholding in the Australian subsidiary was transferred to a company in Hong Kong. And in a variety of ways. This can be done. You can also have a mailbox, a company laying in a country there, and you can make that company buy shares in a locally incorporated company which has no standing, unless, of course, like the relevant treaty provides for that specifically, to bring an investment claim against its home and host state. So yes, it can be done in a variety of ways.
I'll probably just add to this one very interesting case, which is Orascom versus Algeria, which basically illustrates that you don't necessarily need to change the nationality. But if you have a chain of companies controlled by the same investor, and the original investor sells one of the intermediary companies, and that intermediary company manages to settle a win first, then the original parent company might have an issue of inadmissibility or merits. So if that is something interesting, you can look at that as well. One other question that we have is, I'll probably combine them together. There's a question on backlash, and there's a question on the new trend in modern BITs to prevent investors from availing better protection through investment restructuring. Do you see that one affects the other? Do you have any views on that?
Well, yes, we've definitely heard a lot about backlash against investment arbitration. I think that the Michael Weibel's book of that title came out already back in 2010, so good 11 years ago. You know, many of us were still at the beginning of our careers where there was already backlash against investment arbitration, and there's a lot to be said about it, and a lot is being said about it, and a lot of ink has been spilled discussing various points why the backlash occurred and what to do to involve all stakeholders to make sure that the system as such, the mechanism that is provided for resolving the claims has a buy-in from various stakeholders. So of course, given that the contracting parties to treaties are, you know, the masters of the treaty, that it's clear that to the extent that they are unhappy with certain provisions, and we've seen unhappiness from various states at various points in time, quite often where the decisions were adverse to a particular state, including withdrawals from exit convention or cancelling of bilateral investment treaties, then it comes out as a little surprise that the states are trying to draft provisions more carefully to match their expectations and to protect also not only the investment, the foreign investment in the country, but also the what they see as the justice in the system, I suppose. And there's an ongoing discussion with a multitude of treaties, and Energy Charter Treaty being just one recent example. So I would leave at that, and I see that Giorgio has a few thoughts as well.
Well, yeah, I'd say that it's definitely like related investment structuring and structuring to backlash against investment arbitration. Although I think that Philip Morris versus Australia is not really well known by non-lawyers because the case stopped at the stage of the jurisdictional stage. Philip Morris versus Uruguay, it's a completely different story. And that's because the public is, much more interested in cases where public interests are at stake. So in that case, the merits was discussed. And it was the same with the WTO, the shrimp case. It was the same with Perenco versus Ecuador. So when it comes to public interest, then you have strong backlash. But yeah, it is definitely intertwined, and you can look at the 2018 Dutch model BIT, the new model BIT of the Netherlands, to see how these concerns about investment structuring, investment restructuring are factored into that new model BIT. If I remember correctly, for example, that BIT says that the definition of investment, and I'm paraphrasing, does not include, for example, mailbox companies. So you have to have a substantial business activity in that country if you want to qualify as an investor. That's clearly a reaction against corporate structuring. But it also says that arbitral tribunals shall not have jurisdiction if the investor restructured its investment when the dispute was foreseeable. So they basically adopt the same approach adopted by the tribunal in Philip Morris. So now, of course, the path is clear. You have to terminate existing bilateral investment treaties. You have to wait for sunset clauses to roll off, and then you have to negotiate and conclude, which is not easy, new bilateral investment treaties, more precise, more carefully drafted with regard to the definition of investment and the possibility for restructuring before, of course, which will replace possibly in the future the existing very broad BITs.
Thank you. And we have one hand up. Would you like to speak?
Yes, thank you very much. Can you hear me?
Yes, we can.
That's great. Thank you so much for your presentations. I really tried to type my question, but it's a bit complex, so I decided to use the option of raising my hand. My question goes for, and I'm sorry for mispronouncing your name, Agnieszka. My question concerns, well, it seems to me that the question of selling an investment after a treaty breach involves two separate questions. The first one is jurisdiction, and the second one is standing in the substantive sense. So when it comes to jurisdiction, of course, tribunal will see at what time the offer was accepted, offer to arbitrate was accepted by the investor, that investor qualified as that at that time as addressee of the offer, and then the jurisdiction stays fixed throughout the proceedings. And the other question is completely separate question, is to what extent the substantive claim, which follows the rights and obligations and follows the investment itself once it's being sold. And that's a question of standing, more close to the substance than to jurisdiction. Now, my question is, to what extent this difference was actually separately addressed in the case law, if it was at all? Thank you very much.
Sure. Thank you so much for this question. I think to a large extent, the tribunal's case law to date, as you say, has focused on the jurisdictional part, and then it just skipped to the damages when considering the implications of the sale. When you mentioned the sort of standing on the substantive issues, I think to a large extent that might be because, and I'm speculating here because I do not recall any substantive discussion on the merit stage of these issues in the awards that I've seen, is that the claim itself would crystallize at the time of the breach. So this is a time, for example, where a lot of both the obligation and breach and loss all come together, and that's the last point that the tribunal would be looking at substantively. But many other items would be looked at even before. For example, for the legitimate expectations, the tribunal would look for the time when the investment was made, so that naturally precedes any transfer of an investment, because of course, you know, that's the timeline that we discussed. So I'm not entirely sure whether there is any substantive discussion, but my guess is because to a large extent, everything that runs up to the treaty breach is relevant for the merits, and what happens after is not necessarily seen as part of the claim, because the claim may be seen as having crystallized at the time of the breach. But again, there might be implications for quantum of damages, but that's separate. But I welcome other thoughts on this point.
Giorgio, unless you'd like to add a comment, I think we can have just one very brief question on the standard of foreseeability, if you have a like a quick way to answer that.
Well, yes, I'll take that question, but there is no easy answer. So it's very fact specific. It also depends. So in my presentation, I covered just Philip Morris, which adopts a diluted standard of foreseeability, which is less strict than the standard adopted by previous arbitral tribunal. I'm thinking, for example, of PACRIM versus the Republic of El Salvador, or Tidewater versus Bolivia, when they said that the specific dispute should have been foreseeable as a very high probability and not merely as a possible controversy. So what Philip Morris says is that PACRIM, there are two ends. Very high probability, so the dispute, the specific dispute must be foreseeable at the very high probability, and the other end is the dispute or a dispute should be foreseeable merely as a possible controversy. And what Philip Morris says is basically truth is in the middle. So you have to, take a position between these two hands. Having said that, this doesn't say much about what elements a tribunal should assess when to answer the question whether the dispute was foreseeable at a specific point in time. And this is the reason I think why tribunals also use the other test and the motive that they want to see what was the purpose of the restructuring, and that this is also the reason why Philip Morris, the tribunal in Philip Morris, made reference to that. Of course, there was a specific factual objection in that case, but I mean, it may assist, but it's very fact specific. You have to assess all the relevant factual circumstances of the case to see whether the dispute was foreseeable at the time the restructuring was undertaken.
Thank you. That sounds right. I would also add one more thing, which is, as Giorgio said, it has to be the specific dispute that is usually required to be foreseeable. with regard to the specific claimant, so there's been a very interesting line of cases with Venezuela where the situation deteriorated around the whole country, and there's been a lot of claims coming up. And a number of tribunals confirmed that, for example, if the same investor is targeted by, for example, taxation measures and later expropriated, the dispute on expropriation does not become foreseeable at the moment of the taxation measures unless they are the same, the trigger for expropriation. And a number of other awards confirmed that if you see your neighbor, someone in the same business, for example, being expropriated, it doesn't necessarily mean that your own expropriation becomes foreseeable at that moment.
Yes, that we can call that the rightness line of cases, Mobile versus Venezuela. If your claim is not mature, it's not right, then you can restructure and bring a claim, because at the time of restructuring, you couldn't have brought a claim against the state.
Right, so this has been a very, very interesting discussion. Unless we have any further comments, I think we should conclude. And clearly, as some awards confirmed, restructuring is a smart thing to do for the investor, but it also has to be done in a smart way, as we have seen, to avoid any of the potential pitfalls. I hope you've enjoyed the webinar, and please subscribe to our LinkedIn page to see any future updates. And we'll be happy to meet you at future lectures, and hopefully in person as well.
Thank you very much.
Thank you very much. It was a pleasure to be here, albeit virtually.
Thanks a lot.
Thank you. Goodbye.
Bye.
Thank you.